Since being announced in May of 2019, the Commission team has held 5 community meetings around the province, undertaken thousands of hours of investigation, research, and interviews, held 143 hearing sessions over 138 hearing days, heard testimony from 199 witnesses, with an additional 23 witnesses providing evidence via sworn affidavit, and received 1,063 exhibits. In December of 2020, I released my interim report. As with most public inquiries, the Commission was established in the wake of significant public concern about its subject matter, in this case, the nature and extent of money laundering in British Columbia. The issue was initially brought to the forefront by a watchful press, which was aided in its efforts by individuals whose occupations confronted them with evidence of widespread money laundering in certain sectors of the economy. For the past 3 years, I've served as the commissioner for this public inquiry that was mandated to look into this challenging problem of money laundering in British Columbia. Our mandate included a sector-by-sector analysis of the growth, evolution, and methods of money laundering, the acts or omissions of those responsible to regulate those sectors that contributed to money laundering, the effectiveness of the anti-money laundering efforts of the regulators, and the barriers that have inhibited effective law enforcement. My final report is now being released to the public. I hope that today will mark a turning point for the way that governments deal with money laundering in this province. Money laundering is fundamentally destabilizing to the society and the economy that we all want for the province. It allows criminals and bad actors to exploit the very things that we value: stability, sound financial and professional institutions, and personal privacy. Sophisticated money launderers have used British Columbia as a clearinghouse or a terminus for laundering an astounding amount of dirty money. Even though we cannot accurately put a dollar figure on the volume of money laundering that takes place, I conclude in my report that it is a vast amount. While much of this activity has occurred covertly in the shadows, some has happened in plain sight. In the lead up to this commission, concern was raised in the public discourse about the lack of response to what appeared on its face to be highly suspicious funds being used and laundered in this province. Those suspicions were correct, and it was right to be alarmed by this activity and the lack of meaningful response to it. For too long, money laundering has been kept on the sidelines for police, for law enforcement, for regulators, and for governments. Money laundering activity has been and remains to be poorly understood, even by some of the public bodies that need to address it. And money laundering has rarely been given priority. Too often, it has been largely ignored. It's time for that to change. My report puts forward 101 recommendations directed primarily to the provincial government and provincial agencies. Those recommendations range from broad, overarching changes to quite specific reforms required of particular agencies. The recommendations, if implemented, will begin to address, in a serious way, a problem that has grown through decades of inaction and ineffectiveness. The report is more than 1,800 pages long. It sets out my findings of fact after lengthy public hearings and my analysis of complex policy issues and practical questions. I have tried to make recommendations that are based on the best possible standards and that are supported by rigorous analysis, but that are also rooted in real-world practicality. Government, law enforcement, and regulators will need to be focused and committed to change if we are to see a serious and effective response to money laundering. The report is long, but the executive summary is a far more accessible document at just over 30 pages. Following the executive summary, I have set out in one place all of the 101 recommendations which I make. I'm not going to stand here or sit here and spend hours reviewing all the recommendations and key findings. They've been made public. They speak for themselves, but I do want to highlight a few key items. First of all, I recommended the creation of an entirely new office to deal with money laundering. This will be an office of the legislature with a status that will permit independence from the government of the day. I refer to the head of this office as the Anti-Money Laundering Commissioner. This is a different kind of commissioner than I have been and is more analogous to the Human Rights Commissioner. In terms of form, of course, not function. The AML Commissioner will provide permanent strategic oversight of how the province responds to money laundering. The Commissioner will be focused exclusively on money laundering and will provide advice and recommendations to government, law enforcement, and regulatory bodies on money laundering issues. The office will monitor, review, audit, and report on the performance of provincial entities with a money laundering mandate. It will lead working groups and cooperative efforts to address money laundering issues. I want to be clear here, the AML Commissioner's role would be distinct and different than the role I have had as Commissioner of this inquiry, and I am not the person who will fill it should government decide to undertake this recommendation. I also recommend the creation of a new dedicated provincial intelligence and investigation unit, a new policing unit that will lead the law enforcement response to proceeds of crime and money laundering in this province. It will identify, investigate, and disrupt sophisticated money laundering, and it will train and support other investigators and police agencies in their investigations of money laundering and proceeds of crime cases. The kind of unit I recommend will be a high-end and specialized unit, one that has significant expertise and that is structured quite differently than traditional police units. It will be akin to, but not precisely the same as, the IPOC unit that formed part of the RCMP until 2012. The costs of this new unit should be offset by a renewed focus on targeting illicit assets for forfeiture. Assets seized by law enforcement bodies in this jurisdiction have been relatively anemic. We've seen a high of $19.6 million in 2010-2011 to a low of $2.9 million in 2018-2019. These amounts are simply not commensurate with the amounts which are laundered annually in British Columbia, nor with the amounts seized in comparable jurisdictions. New Zealand, for example, has a similar population and GDP to British Columbia, but has achieved much greater success at identifying and seizing or restraining illicit funds. In New Zealand's case, in a comparable, not precisely the same, but comparable period of time, they seized $358 million in Canadian funds, of which 56% was said to be money laundering. I have accordingly made a number of recommendations respecting criminal and civil asset forfeiture, including in the civil asset forfeiture realm, that the province proceed with its plan, which predated the establishment of this commission, to implement an unexplained wealth order regime. In many specific areas, I have made recommendations for regulators, public bodies, and government. In these brief remarks, I have identified only a few of the recommendations which I made to abate the money laundering problem in British Columbia. And I've already noted that my report includes 101 recommendations that are designed to address the manifold aspects of this area of criminal profiteering. I am hopeful that armed with the available tools, the provincial government can successfully take on those who would attempt to corrupt the institutions which British Columbians rely on to serve a coherent and fair social order. As I conclude what has proven to be a challenging but important task, I want to extend my thanks to the participants in the Commission of Inquiry, and particularly to my team, who have worked so hard to complete the lengthy hearings during a pandemic. I also want to thank the people of this province who have been concerned and supported our work. We've done our work in order to serve the public interest. The Commission was created by the provincial government, but it is entirely independent of the provincial government. We've gone about our work independently, and I'm happy to report that the province has consistently respected our independence. This report represents my thinking, not the provincial government's, nor the federal government's, nor anyone else's. It is my analysis and the analysis of my team of first-class lawyers and my recommendations for reform. My aim is to offer advice that is realistic, practical, and effective. There are reasons for optimism, because a new prioritization and support for anti-money laundering will mean that our province can make headway in combating this social ill. Thank you all for being here. We have half an hour for questions, and they will be moderated. I look forward to attempting to answer your questions and providing additional context and information regarding my report in answer to those questions.